Mr. McAvoy, just touching upon the current court case involving federal political parties, is your office pursuing oversight over federal political parties because the Liberal Party used artificial intelligence to identify possible participants in their nomination and candidate selection processes?
Well, first I should say that obviously I have to be very careful in terms of what I say about this case because it is before the courts now. I would say that the case was initiated because of complaints that we received from individuals who were seeking information. I'm just trying to recall off the top of my head. It may have been multiple political parties seeking certain information, and they didn't receive that, and so therefore they complained to our office, and that's what we were looking at. And then the initial issue was simply whether or not my office had jurisdiction with respect to federal political parties operating in British Columbia. Answer to that question by my office was yes, and again, that matters before the courts, and so beyond that, I really don't want to comment about it.
That's fair. Thank you. The artificial excuse me, gentlemen. Thank you. The Artificial Intelligence and Data Act, or ADA, seeks to establish a framework by which we will further regulate at the federal level artificial intelligence. I noticed in your recommendations to the province of BC that you said there should be public guiding principles of AI in British Columbia. I believe it states that AI should apply, that AI regulation or principles should apply to all existing and new programs or activities, be included in any tendering documents by public authorities for third-party contracts or ADS delivered by service providers, and be used to assess legacy projects to be brought into compliance within a reasonable time frame. What I'm reading there suggests that the province of British Columbia has adopted a model similar to that in United States, where they received a public order that all government departments automatically begin ensuring that they are ready to handle the challenges outlined by artificial intelligence. Is that a correct assessment?
Well, my understanding right now is the British Columbia government is reviewing the principles by which it will deal with issues of artificial intelligence. I should say that on the regulation side of things, myself, along with the ombudsperson in British Columbia, have, as you note, set out some guidance that we think should apply. And I should say, by the by, we also strongly support Federal Commissioner Philippe Dufresne's proposals to ensure that where high impact significant matters of AI are being undertaken, that those be subject to privacy impact assessments. It's the same kind of provisions that, in our view, the British Columbia government should be using, and we will be consulting with the British Columbia government as they develop their principles and guidelines as to how AI will be deployed in the province.
Thank you. We've had some discussion here at this committee regarding what a high-impact system actually would be. In your words, how would you define high impact?
Yeah, that's not a term. That's not terminology that we have used in British Columbia. I mean, anytime you're looking at a system that attempts to, first of all, gather large amounts of data that's used to predict, to profile people, that's involved in making decisions about people, I'm not sure how you scale that. To me, any of that that is involved in using data to make those kinds of decisions about people it impacts them. And there's a right to notification where those systems are in place. There should be a right to object. These are the concerns I know Commissioner Dufresne has raised publicly and with the committee, and we are very supportive of the recommendations he's making and that the amendments that he believes should be brought to bear on the federal legislation front.
To 2023 annual report of the Office of the Information and Privacy Commissioner, you highlight the importance of modernizing British Columbia's Personal Information Protection Act, which has not been updated since it came into force in 2003. What do you think are the most important elements of the modernized Personal Information Protection Act? And could any of your recommendations to modernize the Personal Information Protection Act apply to Bill C-27? If so, which ones?
Well, let me start with one area where British Columbia, in my view, is behind, and it's behind federally and my colleagues that I'm with today, and that is on the issue of mandatory breach notification. There is no obligation on private sector companies in this province to report to my office when there's a breach that would cause a significant real risk of significant harm. But most importantly, there's no obligation on those companies to report that to individuals who are affected. That is something that needs to be changed. There are a raft of other provisions that exist, very good provisions that exist in other legislation, including Quebec's. I think of Commissioner Poitras' ability to oversee biometrics in the province, which is it's a burgeoning area, one that impacts people significantly, facial recognition technology, all those kinds of things, where there's an obligation in Quebec to report the implementations of those kinds of programs. I think that's something that British Columbia ought to be looking at. The automated decision-making processes that are included in Bill C-27 should be, I think, incorporated in British Columbia as well. But I would urge British Columbia's government to go a step further than what's in Bill C-27. And again, Commissioner Dufresne has already alluded to those and where he believes, and we completely support, the improvements to those provisions.